A.P.H.A. American Public and Health Association for Science, for Action, for Health. Workers' Compensation, Occupational Health and Safety. Abstract date November 7, 2017. State-based workers' compensation programs, one of the oldest types of social insurance programs in the United States, provide critical medical and income support to workers injured or made sick on the job. More than 129 million U.S. workers are covered by workers' compensation. Every state regulates its own program, and there are no federal minimum standards that guide these programs as there are for other state-based insurance programs. Changes in state workers' compensation programs over the past 20 years have made it increasingly difficult for injured workers to receive the full benefits to which they are entitled. Furthermore, exclusions in many state programs exempt many work-related injuries and illnesses and many workers in high-hazard occupations from receiving workers' compensation. The result is that employers now provide only a small percentage, about 21%, of the overall financial cost of workplace injuries and illnesses through workers' compensation. Instead, the costs of workplace injuries are borne primarily by injured workers, their families, and taxpayer-supported components of the social safety net. States are engaged in a race to the bottom over workers' compensation benefits, and as a result working people are at great risk of falling into poverty from work-related injuries. Reforms are needed to ensure that workers with occupational injuries and illnesses can access the medical and wage replacement benefits they need until they can go back to work. Action steps. APHA supports the following elements of a workers' compensation reform proposal. 1. Congress should appoint a new national commission to study the inadequacies of state-run workers' compensation programs and update recommendations regarding coverage, benefit adequacy, and compensability of injuries and illnesses, as well as how workers' compensation programs can increase incentives to increase workplace safety efforts that prevent injuries and illnesses. 2. The U.S. Department of Labor's Office of Workers' Compensation Programs should reinstate its publication, suspended in 2004, of periodic evaluations of states' compliance with the essential recommendations of the National Commission on State Workers' Compensation Laws. 3. State government agencies should follow the lead of states such as Massachusetts and Maine that have enacted regulations on medical care payments for work-related injuries pending resolution of workers' compensation claims to ensure availability of immediate medical care. 4. State government agencies must ensure universal coverage in their workers' compensation laws and make sure that special categories of workers, such as migratory and seasonal agricultural workers, home health care workers, domestic workers, part-time workers, contractors, immigrant workers, and employees of small companies, are removed from exclusionary language. 5. State government agencies should ensure that employees who work for temporary and staffing agencies can receive benefits through requirements that contracting firms be held responsible for the failure of these agencies to carry workers' compensation policies. 6. State government agencies should increase their efforts to prosecute employers for failure to provide workers' compensation. 7. State governments should ensure that assessments of disability under workers' compensation occur through an evidence-based system that considers physical and mental impairments in the context of an individual worker's education and abilities and the available job market. Use of the American Medical Association's guidelines on evaluating permanent impairment does not meet this standard. 8. State governments must strengthen anti-retaliation protections for workers and make it illegal for any worker to be retaliated against for filing a workers' compensation claim. 9. State governments should ensure that workers can select their own healthcare practitioner for medical treatment under workers' compensation. 10. State governments should ensure that workers' compensation systems do not require or approve employer-mandated post-injury drug testing unless there is a proven nexus between the incident and impairment. However, all work-related injuries must be compensated regardless. 11. State governments should repeal any language that apportions blame for injuries to workers unless there is an equal decrease in the scope of exclusivity that results in expansion of tort remedies.